My name is Greg Peterson. I am the president of the Robert H. Jackson Center, and I welcome one and all to an extraordinary event here at Chautauqua Institution. One housekeeping matter, since as you can see we have several cameras floating around and we are filming this for posterity. If you have a cell phone, please think about turning it off now. That would be greatly appreciated. We are thrilled to be in this Lenna Hall, a hall in which was sponsored by one of the founders of the Robert Jackson Center, Elizabeth Lenna, so there is a real connect. Special event as we're having this roundtable discussion of the Supreme Court's October term 1951, and we'll be discussing such topics as the Steele Seizure case. This event is made possible through the generosity of Chautauqua Institution, the Supreme Court Historical Society, the Robert H. Jackson Center, and the County of Chautauqua, and we thank them all for making this possible. As we've done in the past, we've been delighted to have as the moderator and really the instigator of this panel, Professor John Q. Barrett, professor from St. John's University and Elizabeth S. Lenna Fellow at the Robert Jackson Center. So at this point, I'd like to turn over for introductions of the subject and the panel. Professor Barrett.
Thank you and good afternoon. I'm John Barrett. Welcome to Chautauqua Institution. Our panel this afternoon brings together 5 lawyers who 55 years ago served as law clerks to justices of the Supreme Court of the United States. My co-moderator is Professor Ken Gormley of Duquesne Law School, and our format this afternoon will be 2 segments, a 45-minute segment followed by a brief break, and then a second segment. In the first part, we will survey the justices and some of the cases in the front half of that Supreme Court term, and in the second segment, we will talk about the Steele Seizure case, which came to the Supreme Court in the spring of 1952. Our 5 panelists, lawyers, and honored guests this afternoon are described in extensive biographical information in your program, and I urge you to consult it closely, for they've led amazing, high-achieving, diverse, and principled lives. I'll introduce them briefly, looking across the gathering. Mr. Marshall Small is senior counsel at the law firm of Morrison & Forrester in San Francisco. In 1951-52, he was the law clerk to Justice William O. Douglas. Next to Mr. Small is Mr. Neal Rutledge. Mr. Rutledge is retired from law practice and now living in Washington, D.C. In 1951-52, he was a law clerk to Justice Hugo L. Black. Next to Mr. Rutledge is Mr. Charles Heilmann, now retired from law practice with the Schneider firm in Philadelphia. In 1951-52, Mr. Heilmann was a law clerk to Justice Harold Burton of the Supreme Court. Next to Charles Heilmann is Mr. James Paul. Jim Paul is a retired dean and professor of law at Rutgers University, among other institutions. In the 51 term of the court, he was a law clerk to the Chief Justice of the United States, Fred Vinson. And finally, to my immediate right is Judge Abner Mikva. Judge Mikva is today with the faculty at his alma mater, the University of Chicago Law School. He is retired from the Federal Court of Appeals in the District of Columbia. He's a former White House counsel, a former member of Congress, a former member of the Illinois State Legislature. These gentlemen came to the Supreme Court for service, in 4 cases, 1 year of service, in Mr. Paul's case, 2 years of service, beginning as summer turned into fall of 1951. The Supreme Court sits in a term that is called the October term because it commences its term on the first Monday in October. And in the typical year, that term concludes in June, the entirety of which is known as the October term. In extraordinary circumstances, there have been in our history some special terms. The execution of the Rosenbergs provoked a special term a year after these gentlemen were law clerks. The saboteurs case in the summer of 1942 provoked a special term. But the typical Supreme Court year, this current Supreme Court year, for example, is an October term. So when we talk about October term or OT 51, we are talking about the months beginning on the first Monday in October and concluding in June the following year, June of 1952. Now, what is a law clerk? A law clerk is as you see from their credentials, the achievements in their youth that earned them this opportunity, a very elite special opportunity. It is an opportunity to work on the inside as a member of the personal staff, as a confidential assistant to a justice of the Supreme Court or other courts, which also have law clerk positions. But this is the pinnacle. And so during this term of the court, these young lawyers in their 20s are on the inside as trusted, hands-on, privy to most things, maybe not everything, but most things, assistants to the justices. And they represent here in the 5 with us, 5 of the 9 justices, also had contact and relationships with the others. So in a sense, they are representatives today and for history for the justices whom they served. I'd like to turn to each of our panelists and ask them simply how they came to be Supreme Court law clerks. Marshall Small, how did you get this job?
John, Justice Douglas took his clerks from the Ninth Circuit. He was the Ninth Circuit justice out in the western part of the United States. He did that because he wanted to give law students from that area an opportunity to come back and clerk. Most of the clerks traditionally had come from the Eastern law schools. So the Western law schools nominated candidates to be selected. Justice Douglas did not select his own clerks. He asked someone, in my case, it was a former law clerk, Stan Sparrow, who was a private practitioner in Oakland, and he would interview each of us and then select one. Stanford Law School, which I attended, nominated me as a candidate, and Stan Sparrow selected me. But I did not meet the justice until he came back to the court in early September, late September actually, because I usually stayed late out west and then came back.
Let's work our way from west coast to east. Judge Mikva, coming out of Chicago, how did you come to be a law clerk to Justice Sherman Minton?
Well, Justice Sherman Minton was the justice for the 7th Circuit, which is the Midwestern Circuit, covers Illinois, Indiana, Wisconsin. And he had served, in fact, on the Court of Appeals in Chicago before he was appointed to the Supreme Court. He had traditionally taken his law clerks from Northwestern University in Chicago or from the University of Indiana, which was his alma mater. My dean at that time at the University of Chicago was Edward Levy, who later on became Attorney General of the United States. But the law school was going through a transformation under Levy, and he wanted to up it in its national rankings by getting some clerkships for Chicago alumni. And he literally camped on Justice Minton's doorstep until Minton agreed to pick a candidate, to pick a law clerk from the University of Chicago. And I had been editor-in-chief of the Law Review, and Levy sent me out there, and I passed the interview, and I got a handwritten note, which I still have, from Justice Minton saying, "I'd like you to come with me in the October term."
Let's move to Philadelphia. Charles Heilmann, how did you come to be a clerk to Justice Burton?
Well, Justice Burton was the justice for the Third Circuit, the United States Court of Appeals for the Third Circuit, which covered Pennsylvania, New Jersey, and Delaware. And so he always took one of his law clerks from that circuit, and he had a tradition of taking as his clerk a lawyer who had worked as a law clerk for Judge Goodrich in the Third Circuit Court of Appeals. And so Dean Owen Roberts of the University of Pennsylvania Law School called me into his office.
Owen Roberts, by the way, worked his way up to dean through what position?
Yeah, that's right. He worked his way up to dean from being a Supreme Court justice, retired. Anyway, he called me into his office and said he had a proposal for me, and that is that if I would become a clerk for Judge Goodrich in the Third Circuit, then Justice Burton would probably hire me as his clerk for the next year. And that's what happened. I had an interview with Justice Burton. I think it was a little pro forma, but anyway, he then hired me as his clerk.
Okay. The Owen Roberts and University of Pennsylvania Law School path also involves your experience, Jim Paul. How did you come to work for Chief Justice Vinson?
Well, it was even simpler than my former mentor at Penn, Charlie Heilmann. Owen Roberts just called me in and said, Fred Vinson owes me a favor, and I'm going to send you down to Washington. So I was a product of extortion, I think. I will add this. I got down to Washington. I tried to figure out a lot of things to say, questions that Chief Justice would ask, and so on. I was ushered into his office. I found a man who looked a little bit like a tired St. Bernard.
Perfect.
Bags under his eyes, you know, and bushy eyebrows. We sort of had a dog like that in our house. Anyway, he was more than that. He was a politically very experienced person, sagacious, shrewd, wise, and I felt that I was being just looked over. I wasn't going to get the third degree or anything. And after 5 minutes, he said, well, I guess you'll do. And that was the sum total of it.
That's great. Neal Rutledge, you were coming out of the Yale Law School. How did you come to be Justice Black's law clerk?
By personal influence, not by academic stardom. Although I did all right in law school, I was in the top 20% of my class. But my father was Roosevelt's last appointment to the Supreme Court, and he had served, of course, with Justice Hugo Black. They were very good friends. I had learned to know the justice as I was in high school and growing up and going off to college. And the same was true of Judge Charles Fahey, who was Solicitor General when my father was serving on the court, and they known each other. And so as a tribute to my father, an offer came through to two of my professors at Yale Law School, John Frank and Fowler Harper, saying that basically what it came down to, they said that if I took a couple of courses and if I did all right in them and they thought I was up to it, that these two judges had said they would like me to clerk for them on my graduation. So I spent a year with Judge Fahey and then the next year with Justice Black, and it was a wonderful opportunity for me because I got to see from the inside the two courts that my father had served on.
Now, that gets you into this intimate, proximate, confidential relationship. I'd like to hear now about the boss, the justice for whom you worked, and what the relationship was like during the year, or in Jim's case, 2 years that you were a law clerk. We'll proceed in the same way. Marshall, could you tell us about Justice Douglas, as you knew him?
Well, Justice Douglas had a reputation as a kind of laid-back, casual Westerner by reputation in the public press, but I was cautioned by Stan Sparrow not to expect that, to expect to find a stern taskmaster who would require me to work very hard, and that was true. Justice Douglas was a rather complicated individual because working with him on the court's business, across the desk, responding to his memoranda, he was all business, very stern and not at all relaxed or jovial. If you got him outside of that context, either during the clerkship year or thereafter, he could be quite amiable and amusing, and I think the clerks generally who worked for Douglas had that same experience. Some better, some worse, but all that same way. I'd give one illustration of the jovial side. On the 13th anniversary of his joining the court, he had a little cocktail party in chambers just for those of us who were on staff. And he made martinis the way he used to make them for FDR, and told us about how times were back in the 30s in Washington where he'd been working. And he remembered I'd grown up in Kansas City, Missouri, and so he recalled that he had a speaking engagement there one time, and he took his dog Frosty with him, and was going to stay at the best hotel in town. He got there, the hotel refused to admit him because he had his dog, so the two of them ended up in a motel. And when the Chamber of Commerce found out, they were so embarrassed they sent a case of dog food to Frosty. And Douglas said that thereafter Frosty would never eat any other kind of dog food.
That's very good. Neal, tell us about Hugo Black.
Well, Hugo Black, I think we all, as law clerks when we were there, referred to our justices as the boss. And I did the same with Justice Black, but he, of all the people that I have worked for from grade school through seniority, he was the less of a boss than anybody I've ever known. You got the feeling right away as a law clerk with Justice Black. Obviously, he was in charge. He was the judge. He made the decision. But you felt always that you were working with him rather than for him. And one thing, this was a very difficult year, this 51 term for Justice Black, because his wife was seriously ill and died during the term, and he was very devoted to his wife. And I would have expected on her death that he would have been considerably less efficient in doing the chores, particularly the routine chores of being a justice. But he every morning he appeared, he kept up his work, and it was just marvelous to behold. And frankly, it was a privilege to know him, and to work with him in his office was just a double privilege.
Charlie, what was Justice Burton like as a boss and a personality?
Well, Justice Burton was a senator from Ohio for a good many years, and the desk next to his was taken by Senator Truman. And when Truman became president and there was a vacancy on the Supreme Court, he appointed Harold Burton as a justice. And Justice Burton was a wonderful man, and I guess all the other law clerks always refer to what a kind person Justice Burton was, and that was really true of him. He really treated his law clerks like family. It was a very friendly relationship, and he took my wife and me, Mrs. Burton and the justice took Margaret and me to a play in Alexandria, and John Douglas was the other law clerk. Most of the justices had two law clerks, and John Douglas was the other law clerk, and his father was Senator Paul Douglas from Illinois, so that added fun to the job. But Justice Burton got us and took us to a reception held by the president, and introduced us to the president, and did a lot of very nice things for us. So it was he was a great justice to work for.
Let me stay on the Senate theme and skip to you, Judge Mikva. Tell us about Justice Minton.
Well, on the other side of Senator Burton and Senator Truman was Senator Sherman Minton of Indiana. And Truman used to say those were his two lawyers, so that after he appointed Harold Burton to the court, the next vacancy that occurred, he appointed Sherman Minton. Minton had won one seat, one term as a United States Senator. He was elected in 1934. And as he put it, he wasn't really much of a Democrat at that point. He'd gone down to New Albany, Indiana to practice law, and the Republican Party was full, and so he had too many young, ambitious lawyers in it, and so he became a Democrat and got a little active with Roosevelt's election in '32. And in '34, when a vacancy occurred in the Senate, the state Democratic chairman asked Minton to run for the Senate. And he did, and of course, he won, and as he put it, he won on on Franklin Roosevelt's coattails, and he knew it, so that when he got to the Senate, as far as he was concerned, Roosevelt was the leader, he was a follower, and he was going to be as strong a New Dealer as there was, and he was. He co-sponsored much of the important New Deal legislation, co-sponsored the court packing legislation, co-sponsored other bills that Roosevelt wanted. And when he won that one term, then when he lost in 1940, Roosevelt had appointed him to the Court of Appeals. It was very hard to distinguish in those days what a Midwestern circuit judge was like, because they didn't have many national cases. Most of the cases involved parties in Illinois or Indiana. And so he came to the Supreme Court as really just as known as a New Deal senator and Harry Truman's seatmate. And lo and behold, when he got on the Supreme Court, it turned out he was really quite conservative. And he used to explain it that he was elected on Roosevelt's coattails. He knew what the people expected of him, and he did it. But when he was appointed to the Supreme Court, he was expected to be his own man, and he frequently did things much different than the liberal New Dealers would have predicted. He explained how that even though he was Truman's lawyer and they were good friends, that he did have to go through the motions when he was proposed to be nominated. He went over to see Truman at Truman's request, and they were sitting there, and Truman had the World Series on the television. And Minton, who had been a semi-pro baseball player in his youth, was watching, and he pointed to the player who was up at bat, and he said, "You know, Mr. President, that fellow can hit a homer anytime he's at bat." At which point the fellow obligingly hit one out of the park, and Truman said, "Well, Shea, if you can call him that well on the court, you'll be a heck of a Supreme Court justice," and he got the appointment.
How did he treat you? What was
treated me very well. He was a very kind person to his clerks. He thought that this was a learning opportunity for us. We used to go over to his encouragement to go watch the proceedings in the House and the Senate to learn something about the way the Congress worked. He was concerned about our careers and our well-being. He never overworked us, and even when he would be irritated with our expressing views different than his, it was always civil and jovial. He would tease us a lot about our being left-wingers, because I went to the left-wing University of Chicago. He had a little more trouble with my co-clerk, Ray Gray, who went to the University of Indiana, which was his alma mater, but he'd say they get him even left-wing now down in Indiana.
Jim Paul, tell us about Fred Vinson, the Chief Justice, as your boss.
Well, I suspect he was a little bit different. His relationships with his law clerks, at least during my time with him, it was rather formal. We had a few social events outside court. The only social events that I had to get to know him in a different milieu was like Justice Minton, the Chief Justice was a great ball player fan. He had played second base at the Center College baseball team in Kentucky, the old praying colonels of the Center College. And he therefore felt, he too knew a good deal about the game. And occasionally one of us, even myself, got summoned in to his office and said, I want you to take me out to Griffith Stadium and watch the Senators play. Of course, the Senators always lost in those days, but that was a sort of a different experience. In preparing for this meeting, I did go through David McCullough's biography of President Truman. I did that because Chief Justice Vinson was an extraordinary friend of Harry Truman. Harry Truman admired him greatly for all his political talents. Vinson had been a congressman for 22 years. He'd served in the Roosevelt administration, briefly on the Court of Appeals, came back as Secretary of Treasury under Truman, and the chief were really like that. For the record, John, I'm holding my fingers together. And I did find some quotes. This is what Truman once said of Vinson: "He is a completely devoted patriot with a sense of personal loyalty seldom found among Washington's top men." That says a lot, I think, if one knows Washington. And then again, it sort of may seem strange to us today, but the President and Chief Justice Vinson loved to play poker. McCullough says that Truman was a, quote, loose player who liked to be in the pot, but sometimes shouldn't have been there. Vinson, on the other hand, was an expert, and that was something that Truman admired greatly. Also, the story is reported that one evening while they were sipping away on their bourbon, and this time they were playing blackjack, and Truman was dealing, and Vinson drew a 10 and another card. He needed just one card more, not too high. Anything below a queen would help him win this pot, which apparently was pretty big. And Truman dealt him the queen of spades, so he was out. And the chief exploded and said, "Why, you son of a bitch." And then he said, "Excuse me, Mr. President." I guess that shows something of the relationship. I want to close this by saying that I once sent a book that I'd written. I won't talk about the book, except it was about a history of politics in the Jacksonian period. I knew that Truman was a great fan of Andrew Jackson as president. In fact, he used Jackson as a model. And so I thought, well, this book at least is relevant to his interests. And he wrote back and thanked me and all that stuff. But then he wound up, he said, "I hope you had a grand tour with the Chief Justice. I don't know a finer man." All of that to me just epitomized Vinson. He was liked to be a folksy politician, and yet underneath he was terribly shrewd and knew what he wanted and often got people to do it.
We're going to move in a moment into some of the cases, but I'd like you guys to compare notes on how the justice actually used you, what work you did, the nature of the employment expectations for you as a law clerk. How'd you keep busy day to day?
Well, I'll start since they're all so reluctant. Justice Minton was not an early bird. He would come in about 9:30 or so, and frequently, if we got up early enough, we would be able to get in a round of golf with two of your co-clerks, Howard Trenans and Newt Minnow. We would go out and be back there by 9 o'clock and be hard at work when my justice came in, and I guess when the chief came in as well. Once there, we didn't have that much interchange. There were certain things that Justice Minton expected very much for the clerks to do. One was to do the so-called cert memos. You get a case to the United States Supreme Court by filing a petition for certiorari, in shorthand it's cert. And the clerks, at least in Minton's office, would write memos to the justice as to why we thought that certiorari should be granted or not be granted. And unless certiorari is granted, that means the case isn't heard by the Supreme Court. And only if certiorari is granted, you need at least 4 votes to grant certiorari for the case to be taken and heard. And we would write these memos. That took a good part of the time during the summer and early fall, writing memos on all the cert petitions that were filed. He would look them over, and he always agreed with us if we recommended that cert not be granted. He thought that the court shouldn't hear too many cases. The Chief Justice had a special arrangement where he could put cases on the dead list, which meant that they were not going to be discussed at conference unless one of the justices asked to take it off. And Justice Minton didn't want to even consider the cases that were on the dead list. As far as he was concerned, if the Chief Justice said, we don't need to consider this case, that was good enough for Justice Minton.
Now, each of you also perform this screening function of cert memos?
Yes.
And
Justice Burton had two clerks, John Douglas and me, and we did every other cert petition. Okay. We'd write a short memo telling him what the case was about and our recommendation as to whether he should vote in favor of taking the case or not.
Once the justices meet in the conference and decide what cases they're going to take, and the cases are being fully briefed and they're heading for oral argument, did you have tasks that were part of getting your justice ready for that next phase in the process? Please jump in.
I remember being tremendously impressed very quickly as a law clerk for Justice Black at the difference in the perspective from the Supreme Court from the perspective in the U.S. Court of Appeals. Now, the U.S. Court of Appeals, as Chief Judge McVick can testify, in Washington, D.C., has a particularly special place because it gets a lot of federal government cases that wouldn't appear in the other 10 circuits in the country. So it's a very interesting place to work. But the Supreme Court, and this just staggered me, most of the cases come to the Supreme Court by way of a writ of certiorari, which is a discretionary writ. You apply to the court, and it can be either from a state court or from a federal appellate court. Actually, it can even be from a trial court in unusual circumstances. And you apply for this writ, and then it's entirely in the discretion of the court whether to take the case or not. If the case does not, if the court decides not to take it, there's no precedent so far as the court is concerned. But what we had in our chambers at Black's chamber was every Monday morning this cart would be rolled in by Spencer, and it was just loaded to practically to the ceiling with these petitions for cert from state courts all over the country and from the federal courts. And they had, the volume was just tremendous. And we would divide that in two. Sam Daniels and I were the two law clerks, so we split it down the middle. And it took us a long, better part of a week to write memos on each case as to whether we thought the judge should vote to take the case or should not. So a great deal of our work was on the certiorari end. Okay. But then
in the oral argument phase, what were the responsibilities or the involvements of the clerks? Sure.
Well, unlike the other justices, Justice Douglas did not ask for what they called a bench memo to be prepared when cases were set down for oral argument. Our main job was on the cert petitions, has been described, except one thing was a little bit different. Justice Douglas only had one clerk, traditionally through a large part of his time on the bench, and he was the longest serving justice in the history of the court, with 35 years. Most of that time he only carried one clerk. The year before I was there, he experimented with two, then went back to one, and continued. In later years, he started to take two and then three. But of course, by then, the business of the court had just increased exponentially in terms of the number of cert petitions were filed. In order to keep up with it, you really needed more clerks. At some point, a number of the justices got together and formed what they called a cert pool, in which one clerk from one office would write a memo, a cert memo, for all the offices participated. But Justice Douglas never would do that. He felt that the court really should operate so that each justice looked at things himself, or now herself. Mm-hmm. And another thing that was different in the Douglas chambers was that a number of cases were filed that were called informa pauperis cases. These were traditionally filed by prisoners who were imprisoned and had some claim of constitutional deprivation and were asking for relief. A lot of those cases were frivolous, and the typical practice was to put them on this so-called dead list, so that, and that was usually a responsibility of the Chief Justice's clerk to do that. But again, Justice Douglas felt everybody deserved to have a look, even the informa pauperis petitions, and so he had his clerks look at all those petitions as well and let him know whether there were any petitions that warrant his attention, so make sure that justice was done. Right. So we were busy in those chambers. We didn't do the bench memos, but we did, lots of other things that kept us occupied.
We did bench memos for Justice Minton. After the case was granted, cert was granted, he wanted a detailed bench memo on what we thought the major arguments were, and even indeed a recommendation, though he felt free to ignore those when necessary, as to how we thought he ought to vote on the merits of the case in conference. And they were expected to be much more detailed than the cert petitions, which sometimes could be very short. This is a frivolous case, denied, and that would be enough. But on a bench memo, he expected us to put in all the cases and all the precedents that might possibly decide the question. And then he'd have the bench memo, and he'd be on the bench, and of course it was traditional that the clerks for all the justices had to be there while the case was being argued. We had these little crevices over on the side where we could sit and listen to argument. And almost at least once a day, a note would come over from Justice Minton. Can you find a case that does so-and-so? And either my co-clerk or I would run back to the chambers and tear all the books off the shelves, because we didn't have computers in those days. And of course, we could never find the case he was remembering. And so we used to call it a Justice Minton no case. And we found a lot of no cases.
Let's move into the substance. 1951, 1952, the last year of the Truman administration, the height or depths of the Cold War, the Red Scare, McCarthy era, brought cases involving those issues to the court. Let me begin with you, Charlie. The Sacker case was one momentous case. Tell us what that was about and how you recall it.
Well, the Sacker case was on petition for cert from a decision involving the New York Communist case. There were 11 avowed party leader communists who were tried for violation of the Smith Act, which is conspiring to teach or overthrow the government of the United States by force or violence. And there were cases like that all around the country, and the New York case was the first one. And there were 11 defendants, and each defendant had a lawyer. And the trial lasted 6 months. And throughout the course of the trial, the judge and the lawyers were constantly involved in battles between each other. And the judge would kindly threaten to hold them in contempt, but he didn't. But at the end of the trial, after 6 months, and all the defendants were found guilty, as they were in all those communist cases, he asked the 6 lawyers to stand up, and he said, "I am citing you for contempt of court, and here is a list of the allegedly contentious acts." It was like 20 pages long or something, and he didn't give the lawyers a chance to say anything, and he said, "I find you all guilty of contempt," and he imposed prison sentences, all of them, for up to 6 months. Mm-hmm. Well, they appealed that to the Court of Appeals for the Second Circuit, and the Court of Appeals affirmed those contempt citations. They were totally separate from the guilt of the defendants themselves. They had their own separate appeals. And so the Supreme Court granted certiorari in that case, and The question was whether the judge properly held them in contempt. And the only issue before the Supreme Court was whether the judge properly did that himself. That is, he charged them with the contempt of court, and then he decided himself they were all guilty, even though most of the contempt was against him personally, alleged contempt, and then he sentenced them. And the question was whether that was proper to do that or whether he should have called in another judge to decide that question. That was the only question before the Supreme Court, and the Supreme Court, much to my chagrin, affirmed the convictions.
Did you argue with Justice Burton about how he would vote in that case?
That's one of the many times maybe when I argued with him, because Justice Burton was a conservative Republican, and he was much more conservative than John Douglas and I. We were both liberal, civil libertarians, and that sort of thing. So I argued that what Judge Medina did was an outrage. There was no reason at the end of the trial for him to do all this himself, and it appeared unfair for him to be the judge and the jury in his own accusations.
And the executioner. So much for the influence of law clerks, right? Judge Mikva, let me turn to you. The Feiner case is maybe a cousin of the Sacker case.
That involved a teacher oath in New York City. You have to remember, this is the height of the McCarthy era, and it wasn't that the Russians were coming as much as we were convinced that there was this domestic conspiracy that was going to undermine our institutions by teaching kids to be communists and singing communist songs by Paul Robeson and other terrible things like that that had to be outlawed. And the New York requirement was that teachers had to take an oath swearing they were not a communist or they wouldn't be allowed to teach in the schools. And this one teacher principal by the name of Feiner refused to sign the oath, and his or her case came all the way up to the Supreme Court. And both my co-clerk and I thought that it was outrageous that the teacher, first of all, we have a strong tradition in this country against oaths. It even speaks against oaths in the Constitution. And the idea that a teacher who clearly was acting on principle, she wasn't a communist, would be denied the right to teach because of this law, just offended us. But Sherman Minton, like Justice Burton, was very conservative on these issues. And he came back from conference. We had recommended that cert be granted, but other than that, we tried to keep our views. We recognized that wasn't where he was, and we tried to keep our views to ourselves. And he came back from conference, and he said, "Well, I've been assigned to write the Feiner case. Here's what I want you to do." And it was going to be my turn to write the opinion, the first draft anyway, and so I was taking copious notes, trying to do it exactly the way he thought it ought to be done. And I wrote a draft, and I sent it in to him, and the next day he came storming into our office. He said, "God damn left-wing University of Chicago, I should have known better," and took the opinion from me and handed it to my co-clerk, Ray Gray, who was from Indiana. But Ray was far to the left of me. And when he took over the opinion, he ended up with much more things that obviously displeased Justice Minton. And finally, Minton took the opinion and ignored everything that Ray Gray and I had suggested and wrote the opinion by himself with his secretary and circulated. And I remember that even the justices who agreed with him were very upset with the way it had been written, so that while we didn't have the power to influence decisions, maybe we did have some influence on trying to make the decision consistent with other things the court was saying. But it ended up the law of the land. If anybody wants to take a look at it, you'll find an opinion that did not do very much by way of shedding light, but did shed a lot of heat.
Now, another very significant case in this term of the court involving schools and involving value inculcation was called Zorich versus Clausen. It was about release time from the public schools that would allow students to be recipients of religious instruction. Marshall, tell us about Zorich and how you remember that case.
Well, as you say, John, that was a case that had a program set up to allow students to leave the public school and attend religious instruction off premises, presumably at a local religious institution. And Douglas took the position, which frankly I thought was defensible. I really basically agreed with it, that that wasn't an establishment of a religion, and that the state ought to be free to permit that sort of arrangement. I was troubled by some of the language in his opinion, and that I called to his attention, and we had a frank discussion on it, and he did make changes in the opinion as it finally was circulated. But there were bitter dissents from some of the other justices who didn't agree with that result. Justice Douglas's own views were modified over the years, and he came to, I think in some respects, take views of some of the dissenters in Zorich. I think that was simply an example of a situation where you had a sitting justice who was on the court as long as he was, whose views evolved and changed over time on particular issues, although on some issues he had a particular compass that he followed throughout his career.
Let me ask about one final area in this segment of our program. Brown versus Board of Education and the question of school segregation came to the court in the next two terms, in the 52 term and in the 53 term, culminating in the Brown decision in May of 1954. But a string of segregation cases had been in the court in the years following World War II, and school segregation is before the justices in some preliminary ways while you're law clerks. What do you recall of that issue? Neal?
Well, the school segregation issue was a prominent one, all during the period that my father had served on the court, which he went on in 43. He died in 49. Here we are at 51. But the earlier cases started out, so to speak, from the top down. They involved, for instance, law schools. There were law schools, there were many southern states that had no law school that a black man could go to. And some of those southern states would send a black man that wanted to go to law school and was qualified to, they would pay his expense and send him up north. And he would end up at the University of Illinois or Michigan or somewhere like that.
And the court had marched through that, I like the downward idea.
That's right.
The law schools, the graduate schools. Now we're talking elementary and secondary schools.
That's correct.
Where are the justices on that in 51, 52?
And I can't tell you where the justices on the court were on that. And all I can tell you is that for Black, who was from Alabama and was the most southern of anybody on the court, that his view, as far as I could tell it on that, was that this was a dynamite kind of a case, which would have political ramifications and which would stir the entire country up, but that he was personally in favor of enforcing the same kind of law at the elementary school level and at the high school level that the court had already pretty well established at the college level and the law school level.
Right.
Well, of course, up to that point, the Supreme Court had always taken the position that it was all right for a school district to put the black children in one school and the white children in another school as long as they were equal. So the rule was separate but equal, and the cases all involved the question whether the black schools were equal. But the Brown versus Board of Education case was brought up in a way in which the court couldn't decide it that way. It had to either decide whether a school could be segregated or not. And that was the case that came before us, but the Supreme Court decided not to hear the case in our term. So we really didn't get into the discussion of that case on the merits.
There was an interesting story that at least Marshall Small and I remember. There was a tradition of inviting a Supreme Court justice down to lunch with the clerks. We had our own separate dining room so that we could talk about the cases and not be overheard by lawyers who want to know what was going on those cases. And we would invite one justice down each week to talk to us about cases and what was going on. And one week we invited Justice Frankfurter down, and it was just about this time of the year. It was May, and one of the desegregation cases had been argued that term. I don't remember what it was. I think it was a South Carolina case. And clearly, no opinions were being circulated. So it was clear that the court wasn't going to decide the case that year, because if they'd heard it in the fall, if they're going to decide it, they certainly drafts of opinions are circulating among the justices by May. And one of the clerks had the temerity to ask Justice Frankfurter, who was our guest, Mr. Justice, why isn't the court going to come down with a decision in the desegregation case? This is 1952, May of 52. And Frankfurter looked at us as if we were all wet behind the ears, recent law school graduates, which we were, and said, why, don't you realize this is a social revolution we're talking about? Do you really want us to come down with a case like that in an election year? And we all gasped in horror at the idea that the court even knew when the election was, let alone would consider when to hand down cases. And I remember one of Justice Frankfurter's clerks, Abe Chase, was looking for a hole in the ground that he could fall into and not be there. He was so embarrassed. And then when the same clerk followed up and said, well, Mr. Justice, we don't understand. What does that have to do with whether the case should be decided or not? And Frankfurter explained to us the politics of it. He said, well, here you've got these two candidates running for president. This was Eisenhower and Adlai Stevenson. He said, neither one will read the opinion, but they'll come down on different sides of it, and one will oppose it and one will be for it. And is that the way you want this important case to be put into the public arena? Well, I was a Stevenson Democrat, and I'd like to think that he would have read the opinion. I think he would have come out for it. President Eisenhower made it very clear later on, privately anyway, that he was very much opposed to the decision in Brown versus Board. But if he had expressed himself publicly in the campaign saying, I'm opposed to it, what would have happened at Little Rock, where the only way that the decision was enforced and the peace was kept was because President Eisenhower called out the troops to keep the peace in Little Rock, Arkansas. Perhaps he would have said then, if he had made it an issue in the national campaign and had been elected anyway, which he would have been, maybe he would have said what President Jackson once said, the Supreme Court has got its decree, let them enforce it, which would have been a disaster for the country. So over the years, I began to think that Justice Frankfurter maybe had more sense than I thought he had when I was 25.
Marshall, Jim, sure, jump in, please.
Yeah, I just add one footnote to Ab's report, which is essentially, as I recall it, I think at the time of that luncheon, we didn't know specifically who the nominees were going to be because neither of the parties had had their convention. Although, I think there was speculation that it might well be Eisenhower and Stevenson. So just a minor footnote is all.
Jim?
Well, I just wanted to say one thing. First of all, I'm very appreciative that this vast audience could listen to these garrulous octogenarians reminisce or make up stories, or Lord knows what we are doing. But the school segregation cases, I think the primary lesson to think about here is it required, if the court did so, it required that you overrule a precedent that had been well established many years ago, followed, and never really challenged until these cases came up in the 1950s. Of course, a vastly changed context than when Plessy versus Ferguson, a separate but equal case, was decided. But one reason why it's interesting today is because it raises a question which I think a lot of people thought about. Under what circumstances should the court overrule a well-established precedent? And we have that problem, obviously, coming up at some point in time, I think, for the court to confront Roe v. Wade. It at least is provoking, I think, to think, well, what's the difference between Roe v. Wade and Plessy? If a majority of the court feels that it was a wrong decision when it was made, I just wanted to call that to your attention. It may be obvious.
No, it's a wonderful and provocative thought, beyond our scope to answer it here. Please join me in thanking the panel for this first part of the program. We'll now take a 5-minute recess and then resume in the second part with Professor Gormley leading a discussion of the Seal seizure case.